Be seated. We'll just take some time to get organized and then we'll start. Okay, welcome to the final round of your here already. Stay, please stay. Welcome to the final round, court is in session. We have read the memorials for the applicant and we've read the memorials for the respondent. Thank you very much. The purpose today is really to get to the issues and really on those issues where you differentiate your points of view. So we may have a few questions. Those are not to annoy you, but those are really to get to the legal issues that we want to address, and that's for the best of your argument. So on that happy note, we'd like to invite the applicant to present the case with one final remark. The court is especially interested in the issues of standing on all four issues today. So if you could incorporate your standing arguments in each issue, that would be very nice. Thank you. On that note, please.
Mr. President, Your Excellencies, my name is Valery Bogoev, and it is an honor to appear before the International Court of Justice, pleading on behalf of the applicant, the state of Atania. I will speak for 22 minutes, during which I will address our first and second submissions, namely that the extraction of water from the Greater Enada Aquifer violates obligations of RHAD and constitutes an inequitable use of a shared resource, and second, that the Savali pipeline operations breach obligations of RHAD with respect to the King Canyon complex and must cease. After I conclude, my co-agent, Ms. Deborah Dineva, will speak for 21 minutes and address our third and fourth submissions, and we reserve 2 minutes for our rebuttal. Your Excellencies, and may it please the Court, Atania's first submission is based on two main points. First, RHAD's extraction of water breached the customary obligation of due diligence, and second, RHAD's extraction of water breached the rule of equitable utilization. Turning to the first of those points, under the customary rule of due diligence, states must ensure that activities within their jurisdiction and control do not cause damage to the environment of other states.
Agent, sorry for interrupting you. What is the source of this you argue as due diligence rule?
Your Excellency, we submit that the due diligence obligation possesses a customary character, as reaffirmed in numerous international instruments, such as the 1972 Stockholm Declaration, 1992 Rio Declaration. It has been, moreover, reaffirmed in various General Assembly resolutions and reaffirmed in the practice of this Court in its 1996 Nuclear Weapons Advisory Opinion, Gapchico Nagimaros project case, and recently in its 2010 Pope Mills case.
So, Counsel, what does the due diligence obligation mean then? What's the content of the obligation?
Mr. President, the content of the obligation of due diligence is namely that when states engage in activities that affect shared resources and that are likely to result in environmental harm, must act in due diligence in order to avoid or mitigate the risks of potential environmental harm. In the words of this Court, in paragraph 104 of its judgment in the construction of a road case, when a state engages in a dangerous activity, it bears the initiative in conformity with its due diligence obligation to notify and consult with all potentially affected states. As established in paragraph 26 of the compromis, RHAD extracts water at a consistent rate of 1.2 cubic kilometers per year. This rate of groundwater extraction is 120 times higher than groundwater extraction deemed to carry a risk of causing environmental harm.
So what's your authority for that one?
Your Excellency, the authority on that statement is the 1991 ESPO Convention, which, although is not binding, we nevertheless submit that it clarifies the proportion of groundwater extraction.
So is it your argument that a specific rate of extraction of groundwater is by definition in violation of the due diligence obligation?
Not precisely, Mr. President. The rate of groundwater extraction bears respect with the loss of discharge and the permanent lowering of the water table, which I will address subsequently. Firstly, the obligation of notification and consultations were not observed in the present proceedings.
I'm sorry, Agent, but where do these obligations arise from? You mean from the general due diligence obligation, or there is a specific instrument you rely upon?
Your Excellency, they fall within the scope of due diligence. However, they have been reaffirmed in both the declarations I cited, namely that of Stockholm and Rio, and have been reaffirmed unanimously by the United Nations in their environmental principles on utilization of shared resources. On the obligation of notification, we would note that RHAD presented its plans to unilaterally tap the Greater Oneida Aquifer via a televised address. Following the practice of this court in its 2010 Pope Mills case judgment, information disseminated through press, such as the televised address of Clean Teresa, does not meet the requirements for a formal notification, which contains relevant technical specifications.
So, but Council, what is the purpose of notification? I mean, obviously, the only purpose of notification could be to initiate cooperation, right? And there has been, to a certain extent, cooperation and research as to the effects of the extraction. So, what else should have been done, in your view?
Your Excellency, we submit that the obligation of notification, the notification itself, should have contained relevant technical information, which is set forth so as to allow the other party sharing the resource to assess the potential risks linked with the project.
Are you familiar with the Lac La arbitration?
Excuse me?
Are you familiar with the Lac La arbitration?
Yes, indeed.
Then could you elaborate a little bit as to how that position, aligns with the conclusions of the arbitration?
Mr. President, in that arbitral award, the tribunal held that the obligation of notification is set forth so as to allow the other party to present its interest. Admittedly, in that case, Spain tried to invoke the obligation of notification so to veto the plan of France. However, in that case arose out of the 1866 Treaty of Bayonne. We submit that the notification itself did not meet the formal requirements. And on the consultation, we submit that the consultations is set so as to allow the parties to present their interests so that they can be reconciled. This has been elaborated by this very court in its 1974 Fisheries Jurisdiction case, paragraph 69.
Agent, but assume, on basis of what you argue, assume that the other state is notified. How would it present its position, or how would they oppose this project and so on?
Your Excellency, that occurrence will happen when the parties engage in negotiations and meaningful consultations with respect to the project, as elaborated on two instances, namely paragraphs 23 and 33 of the compromis. At no point prior to tapping the aquifer did RHAD enter or initiate negotiations and consultations with respect to the utilization of the Greater Oneida Aquifer or the assessment of potential hazards. In paragraph 33 of the compromis, subsequently to the occurrence of significant harm within Atania, President Van invited RHAD to enter into consultations so that the hazards stemming from the Savali pipeline operations can be better understood. On that instance, that invitation was declined.
Council, you're familiar with the draft articles on transboundary aquifers, I suppose, right?
Yes.
Clearly there has been a situation of public emergency in this case, right? I mean, it's not that they did have any other choice but to get the water out of the aquifer, right? So would that not make a difference as to your argument?
Your Excellency, it will not make a difference. So as, firstly, the provision relating to emergency situations, as elaborated in Article 17 of the draft articles on transboundary aquifers, assesses emergency situations with respect to aquifers in general, not the climate in the present case. Moreover, and as elaborated by the IOC in its fifth report on transboundary aquifers by Special Rapporteur Chusei Yamada, the emergency provision is still a form of progressive development of international law, and as such as elaborated in the draft articles in the chapter relating to miscellaneous provisions.
And
On
the other articles are not progressive international law?
Some of them are not. We submit that, namely the obligations contained in
To
articles.
cooperate will be.
Yeah, that would be
Of
one.
course.
In that spirit, I would like to turn to a
But
second.
still, it makes sense, right? The article is not there the article is there for a specific reason. I mean, it's only fair that in case there is no access to water being, the right to water being a human right. Obviously, at one point, the state has the right to use its own natural resources.
Your Excellencies, here we wish to make a clarification. In no way do we contend that the respondents should be precluded from utilizing the aquifer. We submit that the manner in which it was utilized breached international law, namely without notification, consultation, and without taking into account the interest of the other party sharing the resource, which possesses the same sovereign rights with respect to it. On that notion, I'll turn to our second main point, which details with the extraction of water and its breach of the customary obligation of equitable utilization, which has been reaffirmed in numerous unanimously adopted General Assembly resolutions and state practice in the form of bilateral and regional agreements such as the Franco-Swiss Genovese Aquifer Agreement, the Nubian Sandstone Strategic Plan, the Guarani Aquifer Agreement, and European legislation such as EU Directive 2000/60. Moreover, the obligation has been...
Sorry, Agent, is this court bound by all these instruments you cite?
Not precisely, Your Excellency. On the General Assembly resolutions, we submit that this court has established that although General Assembly resolutions are not binding per se, they still possess a normative value. This was established in this court's advisory opinion on the nuclear weapons, namely in paragraph 70, where it noted that General Assembly resolutions can establish opinio juris with respect to a certain rule. The same notion was upheld in the Nicaragua judgment. On the judgments of, on the bilateral agreements, we submitted they evidence state practice. Moreover, the rule has been reaffirmed in the practice of this court in its 1997 Gavčíkovo-Nagymaros project case, paragraph 85, and 2010 Pope Mills case, paragraph 177. Although in a more broader sense, in that case, the topic referred to shared rivers. Pursuant to the equitable utilization rule, as enshrined in draft Article 4 of the IOC draft articles on transboundary aquifers, states which engage in utilization of transboundary aquifers must base this utilization on equitable and reasonable accumulation of benefits. As we submitted...
I'm sorry, Agent, what is the difference between equitable and reasonable?
Your Excellency, in some instances they refer to the utilization in general. However, the term equitable refers to the equitable accumulation of benefits more specifically. However, while the reasonableness refers to the utilization. For instance, how the water has been utilized, the rate of groundwater extraction, and others. As we elaborated, the groundwater extraction was conducted at an unprecedented rate. This is reaffirmed taking into account other aquifer utilities.
Excuse me, Councillor, was it possible for Bahad to exploit this water in another way than the one it chose to use?
Indeed it could. Your Excellency, taking into account other utilization programs of aquifers, which are fossil aquifers and are located in arid and semi-arid climates, namely that of the Nubian Sandstone aquifer system, which is shared by Chad, Egypt, Libya, and Sudan. There, the states which have a cumulative population of 140 million people extract at an annual rate of just 2 cubic kilometers. On another example, that of the Hueco-Bolson aquifer, which is a shared transboundary aquifer located in an arid and semi-arid climate and is shared by the United States of America and Mexico. There, 30 million people rely on just 0.69 cubic kilometers annually. We submit that it was this severe overexploitation of the aquifer that resulted in the permanent lowering of the water table.
So is it your argument then that, I mean, it sounds reasonable, your argument sounds reasonable only if there would be evidence that if there would be a lower rate of extraction, then that would not have resulted in the environmental harm, right?
Mr. President, we submit that, firstly, the link between the overexploitation of the aquifer and the witnessing of the permanent lowering and the loss of the natural discharge was reaffirmed by a study commissioned by Atania, which was conducted by an international panel of scientists, which stemmed over a year and concluded unanimously that depletion of the aquifer resulted in those occurrences. We submit that due to this overexploitation, there was a loss of the natural discharge of the aquifer within Atania, a natural discharge, Your Excellencies, on which Atania has relied for generations, as established in paragraph 4 of the compromis. In that instance, in following the jurisprudence of this court, namely the judgments in the Gapchikov and Guimaros project case and in the Pope Mills case judgment, this court has reaffirmed that utilization cannot be deemed equitable if, firstly, one party unilaterally assumes control over a shared resource, depriving the other party of its fair share. Moreover, and in the Pope Mills case, it reaffirmed that the state breaches the obligation of equitable utilization when it does not take into account the interests of the other party with respect to the utilization of the resource and its environmental protection.
Okay, but how a state should take into account the interests of the other party? What mechanism do you envision for this?
Your Excellency, the mechanism we rely on here is namely that of consultations and meaningful negotiations, which were not possible.
But how could...
But you said they're not possible. How do you see this as a solution, and you say that it is not possible?
To clarify, I meant that the respondents did not initiate such negotiations or consultations, and furthermore declined an invitation to enter into such negotiations, and in such precluded the presentation of our interests with respect to the utilization of the resource. That being said, Your Excellencies, I would now like to turn to our second main...
Final point, Council, what remedies do you seek from the court in issue 1?
Mr. President, we seek a judgment that the respondents... We seek cessation and assurances and guarantees of non-repetition with respect to inequitable utilization of the resource. Turning to the second submission, and namely that the Savali pipeline operations breach obligations of RAHAD with respect to the King Canyon complex and must cease. Your Excellencies, both states are parties to the 1972 World Heritage Convention, and as such are bound to follow their treaty-based obligations.
Council, just to clarify, will you present submissions on the one hand on the Stronghold and the other hand on the Sunrise Mesa?
Your Excellency, we will address the complex in its entirety, namely the canyons and Stronghold located in the Atanian territory.
But part of the complex is in the territory of the other state, right?
Indeed it is.
And that's the location where the Sunrise Mesa is lying, right?
Yes.
So does that affect your standing position? Could you clarify that?
No, Mr. President, we submit that the complex should be taken together its entirety, as the formations which are contained within constitute a whole. This has been elaborated both in the 1972 convention and in the work of the UNESCO, with respect to cultural natural heritage sites.
But my only concern is that if you essentially you claim from the Sunrise Mesa, I suppose you claim violations of the UNESCO convention, right? But the respondents' obligations there are owed under UNESCO, but they are only owed within its own territory, right? Now, you being another state, how can you have standing to claim violations of international law if a state commits those violations in its own territory? I mean, you do not seem to have any interest in that, do you?
Your Excellency, we submit that firstly, the King Canyon complex in its entirety, including the canyons, Stronghold, and Sunrise Mesa, are a shared natural heritage site, as elaborated by the joint application of both states' parties to UNESCO. Furthermore, this has been elaborated both in the operational guidelines, and namely that when a heritage site is located over the territories of two states, both states have the obligation to protect and safeguard the entire complex. Article 6.3 of the Convention explicitly provides that no state may undertake deliberate measures which might damage, directly or indirectly, the cultural or natural heritage the natural heritage of other states parties to the Convention.
I'm sorry, Agent, what is the sanction for a breach of this obligation? And is there an established body which can enforce this obligation?
Your Excellency, with respect to the breaches at hand, we submit that the remedies should be the same, namely cessation and assurances and guarantees of non-repetition of this kind of operation of the pipeline. With respect to the authority, we submit that the World Heritage Committee, which although has purely recommendatory decisions, has pronounced in the past with respect to violations of these provisions, and in those instances, the parties have followed what the Commission has prescribed as remedies and corrective measures with respect to the cultural property. Due to the severe overexploitation, there was a witnessed environmental and structural degradation of the King Canyon complex located within Atania. Atania commissioned a panel of geologists which unanimously concluded that land subsidence had resulted in said environmental harm. Land subsidence caused by the overexploitation, the depletion of the aquifer. Atania annexed the geologist reports towards the World Heritage Committee in its application for the inscription of the property on the list of World Heritage in Danger, an application which was granted. This further reaffirms the causal link, and most notably, and that link is again reaffirmed in Clarification 6, which prescribes that the World Heritage Committee indicated for HAD to prepare a plan of corrective measures with respect to the Savali pipeline operations and the King Canyon complex, which we submit elaborate.
Excuse me, Council. Isn't it possible for a state to find some extraordinary circumstances to explain the attempt to the monuments or historical sites that can excuse actually its behavior?
Your Excellency, the respondents have relied on, firstly, as elaborated previously, the emergency situation, and separately on necessity. We submit that both cannot be applied, and furthermore, both this court and the World Heritage Committee have elaborated that states must reconcile their economic situations with respect to the protection of the environment, and namely that of the provision of Article 6.3. There have been 20 cases falling under the scope of Article 6.3. In all 20 of those cases, Your Excellencies, the World Heritage Committee has established that a state breaches the obligation under Article 6.3 when it undertakes development projects in pursuit of specific economic gain and in turn has damaged cultural or natural heritage sites. Such examples.
I'm sorry, but is there a state which has been sanctioned for breach of this obligation?
Your Excellency, that has occurred in the past, namely with, in 1974, with respect to Portugal, and damage of cultural and natural heritage sites within its territory due to development projects. In that instance, there were sanctions by both the UN General Assembly and UNESCO. Most notably, and in examples that I will provide, namely that of the Iguachu Natural Heritage Site and the Ha Long Bay in Vietnam. On both occasions, the party in question, namely the state of Vietnam and Brazil, have pursued economic development to the detriment of cultural or natural heritage sites in those cases. The World Heritage Committee ascertained that those states were in breaches of their obligations. With this respect, Your Excellencies...
Final question, Council, because I can imagine that that your obligations under the UNESCO Convention, and if you compare them to general economic development, then you may that may be the conclusion indeed. But here it's quite different, is it not? I mean, a state on the one hand has an obligation to protect international human rights and has to protect, well, the access to water, access to food, and on the other hand, it is bound by obligations under the UNESCO Convention. Now, ICCPR on the one hand and UNESCO on the other hand. I mean, how do you balance those two interests? And of course, you may answer.
Mr. President, we submit that that balance of interest could have been possible if the respondents did not endeavor to extract at such an unprecedented rate the groundwater contained in the aquifer without consulting or notifying Atania and taking into account the potential hazards linked with the Savali pipeline operations, and without any cooperation whatsoever with the state sharing the resource, the natural resource, and sharing the cultural heritage which was damaged by this economic development project.
Thank you, Council.
Thank you for your time.
Thank you very much. Then I would like to invite the second counsel for the article. Apparently we need to speak a little bit louder, so if you may.
Okay.
That's your turn.
Mr. President, Your Excellencies, my name is Deborah Dinova, and it's an honor to appear before the court as a second agent for the applicant in today's proceedings. In the course of the next 21 minutes, I will be submitting our third and fourth claims, namely, that the Rahat must immediately return the Rabbi Cypher to Atania, and that Atania owes no compensation for any costs incurred in relation to the kin migrants. May it please the court, we would like to start with the third submission, namely, that the Rahat must immediately return the Rabbi Cypher to Atania. And here, we would like to address two main points. Firstly, Rahat is bound under international custom for the restitution of illicitly imported cultural property.
Counsel, could you elaborate on standing for your claim? Do you have standing to bring your claim?
Your Excellency, even though our claim concerns that Atania is the lawful owner of the Rabbi Cypher, we do not rely on the ownership rights over the Rabbi Cypher as a basis for our claim for restitution, rather than we rely on obligations which are directly owed to the state of Atania. First, the customary rule for restitution of illicitly imported cultural property to the state of origin, in our present case Atania, and secondly, we rely on a breach of the obligation of Article 18 of the Vienna Conventional Law of the Treaties by the respondent as a basis for restitution of the Rabbi Cypher. We would like to start with the customary rule for illicit import of cultural property. Your Excellencies, as defined in Article 6 of the 1970 UNESCO Convention, illicit import is import which is done without an export license or without the prior authorization of the state of origin. This rule for the restitution of illicitly imported cultural property to the state of origin has been widely recognized by the international community.
I'm sorry, Counsel, but first of all, how do you argue that this is cultural property at all?
Your Excellency, firstly, the Rabbi Cypher does fall under the definition of the 1970 UNESCO Convention, Article 1, which concerns cultural property. Additionally, the reservation which Atania made upon ratification of the 1970 UNESCO Convention further elaborates on the cultural heritage of Atania, which will be included as cultural property. And it is evident by this reservation that the Rabbi Cypher falls in this category.
Excuse me, Counsel, does the 1970 Convention apply to this case?
No, Your Excellency, we do not rely on the 1970 UNESCO Convention as a basis for restitution, since it was not enforced for the respondent at the time of the illicit import. We're simply relying on the definition of cultural property, which is given by the Convention.
But why do you rely on it and argue that it is not applicable?
Your Excellency, since the 1970 UNESCO Convention was ratified by a significant number of states, it is clear that it is widely accepted the definition of cultural property set in Article 1 of this convention. And additionally, almost all legislations in the world of all countries have special provisions with regards to cultural property, and cultural property which is discovered by excavations within the territory of a state are considered cultural property of that state.
I see your point, but why don't you argue then that the convention is binding because it has been ratified by a lot of countries? Why do you argue that it's not applicable, but only the definition is applicable because the convention was ratified by a lot of countries? Why don't you argue that it is applicable at all because it has become a customary international law?
Your Excellency, we do submit that there is a customary rule for restitution of illicitly imported cultural property, which has crystallized since the conclusion of the 1970 UNESCO Convention and is supported not only by the Convention, but also by state practice outside of this Convention. Actually, state practice in this regard has been very consistent and uniform. For example, state practice can be derived from the national jurisprudence of domestic courts. In this regard, we can rely on various decisions in states such as the United States, France, Italy, and Iran. And we would like to clarify that the decisions which we are citing were prior to the entry into force of the 1970 UNESCO Convention for these states in question. Therefore, it is to be considered state practice outside of the 1970 UNESCO Convention. Your Excellency,
I'm sorry, Counsel. Is it possible to use domestic legislations or decisions to establish a general practice of the states?
Yes, Your Excellency, as established by this court in the jurisdictional immunities case, state practice can be derived both by domestic courts' decisions and national legislation, and we rely on both as evidence of state practice. National legislation further supports our claim for restitution. For example, the legislation of Australia, which provides for the restitution of illicitly imported cultural property to the state of origin. Your Excellencies, we submit that even in the rare cases where restitution of cultural property was declined, this further supports our rule. For example, in the Elgin Marbles case, the United Kingdom did recognize the existence of the rule for restitution of illicitly imported cultural property, but rather based its decision on a different reason, and namely the legal transfer of ownership. And as established in the Nicaragua case, paragraph 186, when states are basing their decisions on exceptions contained within the rule, they further reaffirm its existence. Therefore, we submit that the respondent is bound under this customary rule to return the Ruby Cypher to Atania.
So, Council, has there been any international court that has ever ordered the restitution of artifacts? That would greatly help.
Mr. President, usually the cases for restitution of illicitly imported cultural property have been decided by domestic courts. However, the ICJ has rarely been in the position to rule upon this customary rule. However, in the Temple of Prayer Vihar case, the court provided that cultural objects should be returned to Cambodia in the case.
And in that particular case, was the cultural object owned by the state or was it owned by its citizens?
Mr. President, actually there is no evidence of the ownership over the cultural properties in that case, since Cambodia actually did not define any particular cultural object and only referred to cultural objects which were found within its territory and did not specify on a specific object.
And in this particular case, who owns this artifact? Who is the owner of the artifact?
In the present case, we do submit that the Atania is the lawful owner of the Ruby Cypher. It was discovered within the territory of Atania, as evidenced by paragraph 12 of the compromis, and is part of the cultural heritage of Atania. However, we do not base our claim simply on the ownership rights over the Ruby Cypher.
But isn't this properly an ownership claim which should be reviewed and considered by the domestic courts of either of the two countries and not by this court?
Your Excellency, since evidenced by the compromis, the respondent has refused our request for restitution. Therefore, we are claiming restitution before the court.
But is your state the proper party to lay a claim for restitution of this object? Because isn't it a part of the cultural heritage of the Kim people?
No, Your Excellency. We do submit that Atania, as a state of origin, has the right of possession over the Ruby Cypher, and even though there is a cultural link between the Kim people, they do not have property rights over the Ruby Cypher, and this has never been recognized. Property rights with regards to cultural property to minorities.
But in this case, why don't you lay a claim before the domestic courts of the other country and request restitution from them? Why do you go to interstate relations to decide an issue which is basically related to ownership rights, even if for a cultural artifact?
Your Excellency, as evident by paragraph 52, we did request the restitution from the respondent. However, it refused to grant us this restitution. How did you request it? Formally, namely by diplomatic channels, and the Hadi Minister of Culture, which is responsible for the restitution of the cultural property, formally rejected our request. Your Excellencies, we also base our claim for restitution on the breach of Article 18 of the Vienna Convention Law of the Treaties by the respondent. This article provides explicitly for signatory states to refrain from acts which are inconsistent with the object and purpose of a treaty prior to its entry into force.
So now you do rely on the convention?
Your Excellency, we rely on the Vienna Convention Law of the Treaties as a source of this obligation, not on the 1970 UNESCO Convention. Article 18 was in force for Rahat at the time that the illicit import occurred, and therefore Rahat was bound by its interim obligation not to act inconsistent with the object and purpose of the 1970 UNESCO Convention, since it has already ratified it.
But now you are relying on the UNESCO Convention. I'm a little bit confused. I'm trying to construe your argument here.
Mr. President, the main source of the obligation which we are relying on is Article 18 of the Vienna Convention law of the treaties.
Yes, of course, I understand. So you rely on the Vienna Convention to interpret the UNESCO Convention, I suppose?
No, actually, it's the contrary. We rely on the 1970 UNESCO Convention to define the object and purpose of this treaty and to apply it to the obligation of Article 18.
Okay.
But you said that the UNESCO Convention is not applicable.
Yes, Your Excellency, we are not trying to bind the respondent to any specific provision or obligation under the 1970 UNESCO Convention. The source of our obligation is the Vienna Convention law of the treaties.
I'm sorry, Council, I just have one question. Is it possible for a state to be liable for a breach of the Vienna Convention and the law of treaty? Is it possible that a state engages its international responsibility on this ground only?
Yes, Your Excellency. Even though there is no case law on Article 18 before the court, this obligation is explicitly for signatory states, which means that states are exactly responsible under this article.
Sorry, just one last question. Do you have any cases before this court where we decided to declare a state responsible for the violation of the Vienna Convention on the law of treaties?
I'm unable to answer this question. However, we do have cases where courts have relied on Article 18. For example, the European Court of Justice has held a decision based on Article 18 and has, in the Opel Austria case, has declared that the respondent has acted inconsistent with the object and purpose of a treaty and contrary to the legitimate expectations of the applicant, and therefore was responsible under international law.
Council, what was the sanction for this non-compliance?
Your Excellency, the sanction was compensation because it concerned monetary compensation. However, in our case, we submit that the object and purpose of the 1970 UNESCO Convention is the prohibition on illicit import of cultural property and the restitution of such to the states of origin, and Rahat defeated this object and purpose by two actions of the state. Firstly, as evident by paragraph 50, Rahat allowed the illicit import within its territory, and secondly, in paragraph 52 of the compromis, the respondent formally rejected a request for restitution, and these actions amount to a defeat of object and purpose of the 1970 UNESCO Convention, and we request from the court restitution as a form of remedy in the form of the return of the Ruby Cypher.
Also, I have one final question, because I think your argument is clear that you want to make to the court. However, my question would be, how does Article 18 of the Vienna Convention and the Law of Treaties then relate to Article 20 and 21 of the UNESCO Convention? Being Article 18 of the VLT essentially says that a state is only bound by a treaty after its ratification, but after signatory it's supposed to not to do anything against the object and purpose of the treaty. I will grant you that one. However, since you're sort of relying on the UNESCO Convention, Article 20 and 21 provide for a different system to be bound by a convention. It doesn't adopt the two-stage that the Vienna Convention and the Law of Treaties adopts by saying signatory and then ratification. I think Article 20 and 21 of the UNESCO Convention provide a system where it's just ratification. So that system is different than the system in the Vienna Convention. So if this treaty deviates from the Vienna Convention, then should we not apply those articles instead?
Your Excellency, if we consider the 1970 UNESCO Convention being a special rule with regards to the Vienna Convention law of the treaties, then we would have to rely on this article. But this does not change the line of our argument, namely that the respondent is bound to return the Ruby Cypher to Titania. Your Excellencies, we would like to turn to our fourth claim, and here we would like to prove that Titania does not owe any compensation with regards to the kin migrants. Since firstly, we submit that Atania did not commit any human rights violations with regards to the clan king, and in any event, these do not amount to persecution. Your Excellencies, in order to obtain compensation, the respondent must prove that the king were refugees and that it was bound under its treaty obligation of non-refoulement of the 1951 Refugee Convention.
Counsel, just a small procedural point. Do you recognize that the respondent has standing to bring the counterclaim?
No, Mr. President, actually we do not, since firstly, human rights are not owed to other states, they're owed to individuals, and here the respondent is not exercising diplomatic protection on behalf of the refugees. Their claim is to compensation to their state, not on behalf of the refugees.
So states can never have standing to protect the interests of people outside their own territory?
Your Excellency, there are certain occasions in which, for example, in Article 9 of the draft articles on diplomatic protection, there is a situation in which refugees can be subject of such diplomatic protection. However, it is, in this article, it is provided that it cannot be against the state of origin.
Counsel, are you acquainted with the notion of universal jurisdiction?
Your Excellency, we do not argue the jurisdiction of the court.
No, I'm not speaking about the jurisdiction of court. Do you know what is universal jurisdiction?
I'm sorry, I'm unable to answer this question.
Okay. Universal jurisdiction is jurisdiction that each state can exercise regarding breaches of rights and commonly shared values in international law. So, in view of this, isn't it possible that when there are grave violations of human rights, other states can interfere and bring blame?
Your Excellency, actually in paragraph 91 of the Barcelona Attraction, the court has provided that other states do not have the capacity to protect persons which are not their nationals if they're not exercising diplomatic protection. We submit that the respondent is not claiming this. Your Excellencies, we would like to first prove that Atania did not violate the right to food as enshrined in Article 11 of the International Covenant on Economic, Social and Cultural Rights. The content of this right has been elaborated by the Committee in General Comment number 12, and the Committee in paragraph 7 has provided that the adequacy of food would depend on the prevailing conditions of each state, and furthermore, that there is a distinction between the unwillingness of a state to provide and the inability. And Your Excellencies, this is...
Counsel, in the interest of time, I think we would especially be interested in any direct violations of international law. So could the respondents not argue that causing a refugee crisis essentially violates the territorial integrity or the sovereignty of the state, and those rights are owed directly to the state? Could you elaborate on that, please?
Yes, certainly, Mr. President. If an obligation is directly owed to the respondent, it would have standing to this claim.
Yes, so could this not amount to a violation of those rights?
However, in order to prove that a refugee crisis has directly injured them, they must first prove that the kin were indeed refugees, and we submit that this is not the case, since first we did not violate the rights of the clan kin, and in any event, the treatment suffered by them did not amount to persecution.
Excuse me, Agent, how is it possible that the kin population is not considered as refugees when 500,000 of them fled from their territory? How do you justify this movement of population?
In order for persecution to be established, Your Excellency, firstly, there must be human rights breaches, and we submit that there were no such in the present case. And secondly, we submit that even if the court accepts any alleged human rights breaches, they would not amount to persecution, since they lack one of the constitutive elements of such, namely intent.
Sorry, just one last question. So why did the kin leave your country?
Your Excellency, there are several factors which led to such huge migration. As is evident in the last 30 years, climate change has been a big reason for migration. And here, in the present case, there was a huge temperature increase, droughts, and other extreme conditions, which also affected these kin people and their ability to provide for themselves. And we submit that on behalf of our government, there was no intent and no target on conventional grounds with regards to the clan kin.
I'm sorry, of course, you will have time to answer the question. You are saying that nothing was targeting specifically the kin population. Well, actually, among the 17 tribes of your federation, they are the only ones that left your country. So how is it possible that only the kin population decided to flee?
Your Excellency, firstly, we submit that the differential treatment suffered by the clan kin does not amount to discrimination, as elaborated by the committee. In General Comment number 20 on the subject of non-discrimination, differential treatment does not amount to discrimination when it is pursuing a legitimate aim, and in the present case, maximizing the agricultural production of the state and ensuring the general welfare of the population. Thank you for your kind attention.
Thank you, Councillor. If you just give us 1 minute, then we'll proceed. I will remind the respondent that we're very eager to learn about STEM. Please proceed.
Your Excellencies, may it please the Court, my name is Stolar Rogoshev, and I'm honored to appear before you as an agent for the respondent. In the next 22 minutes, I will present to this Court that, contrary to the applicant's claims, the extraction of water from the Great Inata Aquifer has been conducted in a manner respecting the norms of international law and has not violated its obligations in relation to the Kin Canyon complex. In the following 22 minutes, my co-agent, Mr. Roslav Kostov, will elaborate on the matters concerning the Ruby Sipa and the expenses for the fleeing from Atania Kin clan. We reserve 1 minute for a rebuttal. With the permission of the Court, I will now address the first issue, namely that this Court should find in favor of the respondent that the extraction of water from the Great Inata Aquifer has been conducted in an equitable manner. First, the due diligence obligation is inapplicable to this case. Second, there are existing rules of international law that are more suitable to the present case. And finally, Rahat is in no violation of the rules deriving from this international law. Your Excellencies, we do recognize the obligation of due diligence as a customary international rule. However, Your Excellencies, we would like to present to this Court that, to the present case, it is not suitable and inapplicable. The applicant has referred in their pleadings to the cases concerning the Trail Smelter case, the Corfu Channel case, and we want to emphasize on the last one, the Gapchigovo-Nagy Maros case. These cases refer to matters that, at the time of the decision of the Court, were not resolved by any specific rule of international law. And in order for the courts to protect the rights of the states, they referred to the very general rule of due diligence precisely to protect these rights.
Well, but if you argue Trail Smelter, that's clearly an environmental case, is it not?
Yes, Your Excellencies, and the Corfu Channel is about mines in the Corfu Channel, and we believe that this is a very general obligation that has been used in a great variety of cases with a variety of objects. Your Excellencies, when the Court gave its decision in the Gapchigovo-Nagy Maros case in 1997...
But if I can take you back to Trail Smelter for a second, how do you place Trail Smelter then because you say it's unsuitable and it's not applicable? Trail Smelter provides clearly the duty to the due diligence obligation for transboundary environmental harm. And if you look at those proceedings, then it was specifically addressed what damages were done and how those damages were calculated. I think that's a very good example of a case that we could apply here, right?
Indeed, Your Excellency, the Trail Smelter case has been referred many times in international law. Nevertheless, it is a very old case, and there are more recent cases of environmental harm, and especially with watercourses. And for this reason, we would like to refer specifically to the Gapchigovo-Nagy Maros case and the Pulp Mills case that the applicant referred to as well. Your Excellencies, when the court gave its decision in 1997 concerning the Gabčíkovo-Nagymaros case, there was no rule of international law governing the utilization of transboundary watercourses. The United Nations Convention on the Non-Navigational Uses of Watercourses has also been adopted by the United Nations in 1997. However, it has entered into force in 2014. In the following cases concerned with shared water resources, namely the Pope Mills case, the court has recognized different obligations deriving from the rules of international law, and it is our position that it was influenced by the United Nations Watercourse Convention.
Council, before we go there, could you please elaborate on why we should apply the body of international law for watercourses rather than the body of law for general, transboundary harm?
Your Excellencies, it is our position that since it is strictly and more specific to shared water resources, it is more applicable than the general rule of due diligence. Furthermore, the obligations deriving from the Watercourse Convention are in fact have their origins in the due diligence obligation, and this court has stated in the Pope Mills case, and this is a little inconsistency with the facts from the applicant's claims, that...
Sir, Counsel, do you see any watercourse in this case?
No, Your Excellencies. Nevertheless, in the development of the draft articles on the law of transboundary aquifers, the International Law Commission has referred to this Watercourse Convention on numerous occasions. Furthermore, it is in the scope of this convention, groundwater, and it is our position that they are very suitable for this case in particular.
So you basically say that you make an analogy.
Yes, Your Excellency.
But if you have a very general rule which says that you have to apply due diligence, and you have a case where you make an analogy, which rule should apply? The more general one, which can encompass this situation, or the one which you want to apply by the ways of analogy?
Your Excellencies, we maintain that the Watercourse Convention is more suitable, following from the principle that the special law derogates the general law. And in the case concerned, in the Barcelona traction case, this court has actually utilized analogy in its decision making. We maintain that this court can in fact use analogy to this watercourse and use the draft articles on the law of transboundary aquifers to further acknowledge the nature of aquifers and how they should be utilized and the obligations deriving from them.
So, Council, moving to the more merits part of your claim then, I mean, if we would apply the law that is more specific, as you say, in relation to groundwater and water courses, what specific obligation then would you want us to apply, or what has been breached?
Your Excellencies, it is the applicant's claim that there is in fact significant harm and that the aquifer has been utilized in an inequitable manner. These obligations...
But you don't need to... Okay, fine.
These obligations can be found in the Watercourse Convention, the draft articles on the law of transboundary aquifers, and have been referred to in the Pope Mills case. It is our position that Rahat has complied with these obligations. First, Your Excellencies, the applicants claim that the recharge rate, the extraction rate of the aquifer is the greatest violation here. However, there is a little inconsistency. In Article 4 of the draft articles on the law of transboundary aquifers, the International Law Commission has strictly said that the obligation not to extract an aquifer in consideration with its recharge rate is only for rechargeable aquifers. And as we can see from the compromis, the Great Inata aquifer receives a negligible amount of recharge and can be classified as non-recharging. For this reason, Your Excellencies, we maintain that the obligation is not standing for the particular case.
Excuse me, Ancient, I think that the claimant had an argument about all the procedural obligations that you owe to their country, meaning the obligation of notification and cooperation, and not really the fact that you want to exploit the aquifers. So what do you answer to the claimant regarding those specific obligations?
Your Excellency, in the Human Rights Committee in the Silva versus Uruguay case, in paragraph 130, has asserted that when a state is derogating from its obligation of notification in order to protect its right deriving from the International Covenant of Civil and Political Rights, it may in fact build a defense based on this derogation. It is our position that the obligation of notification, for these reasons, is not breached. Proceeding now to a first obligation, namely the obligation to utilize the aquifer in an equitable manner. It is the International Law Commission's opinion that equitable utilization of aquifers should result in, equitable allocation of benefits among the aquifer states.
So how is it equitable then, Council? I mean, there's been large human rights violations as a result of the use of your water. There has been an environmental catastrophe. So how is that equitable?
Your Excellency, first, we submit that there are no violations of human rights on Atenia's side, since, as we can see from the compromis, 98% of the substitute farmers of Atenia are the Kin clan, and they live east of the Kin Canyon complex, and the drought has appeared in the region south of the complex. For these reasons, we maintain that no vital human needs were threatened on Atenia's side. Furthermore, Your Excellencies, this, my apologies, the reduction of the amount of water in the Great Inata Aquifer in the catastrophe are more relevant to the obligation of not causing significant harm, on which I will elaborate.
And applicants have argued that there's been several instances in state practice where extraction was allowed, but only to a limited extent, and not to the extent that you are extracting the water from the aquifers.
Yeah.
Now, given the fact that there has been environmental harm, can you maintain your position that you've really complied with your obligation to use it equitably?
Yes, Your Excellency. To prove that we have complied with our obligation, I would like to refer first to the threshold of significant harm. Your Excellencies, every exploitation of natural resources poses threat to cause some harm. What is of importance to this court is whether it is significant or not. The threshold laid out by the International Law Commission is that the harm should be more than perceptible and that it impedes the socio-economic development of the state. Your Excellencies, the people of the Nomad Coast have relied on the discharge of the aquifer for many generations. It is in the nature of aquifers that discharge is in fact related to recharge of aquifers, and as we noted earlier, the recharge rate of the Great Inata Aquifer is already negligible at the time when the research was conducted, and since then the Nomad Coast has suffered a drought period, which is a result of record low rainfall, which is in close relation to the recharge rate of the aquifer. For these reasons, we maintain that Rahat has in fact engraved the situation by extracting the water from the Great Inata Aquifer. However, it is not the sole reason that Rahat started losing farmland. And although that the damage is perceptible, cannot be classified as significant.
And then how do you think the court should weigh the reports relied on by the applicant that show that there is a causal link between extraction of water and the environmental harm that's been done?
Yes, Excellencies, we do not waive their report. We just maintain that it is not the sole reason for the loss of farmland. And we firmly stick to that point. Concerning the equitable utilization, Your Excellencies, when determining the equitable utilization of aquifers and water courses in analogy, Articles 5 of the draft articles on the law of transboundary aquifers and Article 6 of the Watercourse Convention provide us with the rule that that we should take in consideration the factual circumstances of the case, and primarily when there are vital human needs threatened on one of the sides, the utilization is equitable. Furthermore,
And Article 6 says you should take all appropriate measures to prevent the causing of significant harm to other aquifer states. Now my question would be, now that you know that there is damage, have you ceased the extraction of groundwater?
Your Excellency, alternatively, if this court decides that there is in fact significant harm, we would like to refer to Article 10 of the Water Course Convention and Article 5 of the draft articles on the law of transboundary aquifers, which give us information that the obligation not to cause significant harm is limited when one of the states is utilizing the shared water resources in order to protect the vital human needs of its population. Rahad was in fact safeguarding the vital human needs of its population, since 70% of the water has been used for the agriculture, which supports the life of the respondent's population. With this, Your Excellencies, we maintain that the Savali pipeline operation and the extraction of water has been conducted in compliance with the norms of international law, and we would like to proceed to our second submission. This court should find in favor of the respondent that the Savali pipeline operation was conducted in compliance with the norms of international law in relation to its World Heritage. First, Rahad has complied with its obligations deriving from the World Heritage Committee. Second, it is our position that in the decision-making of this court, it should be noted the opinion of the World Heritage Committee. And finally, in any event, there are no grounds for cessation if this court finds that there is in fact an obligation. Before I begin, I would like to emphasize that I will be referring to the operational guidelines for the implementation of the World Heritage Convention, since it is a codification of
Council, it appears to be an issue that you don't want to address for all of you, but could you elaborate on the standing issue? In your view, do you think the applicants have standing to bring the claim to begin with?
My apologies, could you clarify your question?
Do you agree with the applicants that they have standing to bring this claim? Or do you challenge that claim?
I still can't understand.
Do they have the right to bring the claim on behalf of the state?
Yes, Your Excellency, I have been officially authorized.
No, I mean the applicant.
Could this state bring a claim for this claimed violation?
Yes, Your Excellency, since both states are in fact host states of this heritage, and we maintain that both states have the obligation to protect the heritage. Your Excellencies, the operational guidelines for the implementation of the World Heritage Convention are a codification of the decisions of the World Heritage Committee that are binding upon the parties, and both states are parties. By including the Kin Canyon complex in the World Heritage List, its outstanding universal value is internationally recognized, and the host states have undertaken various obligations in order to protect this heritage. We recognize that host states have the obligation of reactive monitoring, found in paragraph 169 of the operational guidelines, and it is to report and assess impact studies each time work is undertaken that might cause harm to the World Heritage. Rahad has issued an environmental impact assessment and has submitted the Savali pipeline operation to the World Heritage Committee, as can be found in clarification number 3 of the compromis and paragraph 24 of the compromis. By doing so, it has complied with its obligation of reactive monitoring. According to the operational guidelines for the implementation of the World Heritage Convention, necessary measures are specific for each case and are to be determined in the light of the present case and in consideration with the capabilities of the host state. Rahad has requested an expert advisory opinion by submitting the Savali pipeline operation, and the World Heritage Committee and its advisory bodies have given their decision. Rahad has conducted the whole operation in compliance with their decision. And Your Excellencies, we have no evidence in the compromis about the particular measures prescribed in the decision. Nevertheless, the applicant has not in any way contested that we have not complied with these obligations. Rahad has limited the extraction of water to more than 15 kilometers outside of the buffer zone and has complied with the obligation not to violate this buffer zone as well.
So, but Council, clearly the result is that there has been damage to the UNESCO properties, to the canyons, to the stronghold, and to the Sunrise Mesa. So there has been damage done. You cannot deny that.
Yes, Your
And
Excellency.
there has been international reports which show that there is a causal link between those damages and the pipeline.
Your Excellency.
So if there is a causal connection, then by definition you have violated your obligations under UNESCO, right?
Yes, Your Excellency, and we are recognizing our responsibility for the damages on the World Heritage. And in fact, the World Heritage Committee has requested us a program of corrective measures, which is in fact, of course, complying with our responsibility to protect the heritage. And we shall present this program of corrective measures in the 2017 meeting in Krakow. My apologies.
So you agree that you bear state responsibility on issue 1?
Yes, Your Excellency.
Okay.
However, the World Heritage Committee could have requested cessation, and it did not do so. By
But the
doing so,
applicants are asking it. Perhaps the applicants want to ask it in these proceedings.
yes, Your Excellency, and we maintain that there are no grounds for cessation, and when determining whether cessation should arise, this court should take in consideration the opinion of the World Heritage Committee, since it is expert in the sphere of World Heritage.
Excuse me, agent. Yes, indeed, they are experts, but I think that this court is actually the international judge for all the violations of treaties and so on. So how is it possible that after having admitted your own international responsibility, we cannot decide of any remedy on it?
Your Excellency, first we would like to affirm that we bear responsibility before the World Heritage Convention for the damages done. However, we have not breached our obligations in relation to take the appropriate measures, and therefore there is no international wrongful act and there is no grounds for cessation to arise. Furthermore, Your Excellencies,
I'm sorry, Counsel, but I'm complex to understand. You say that you breached international law, that you should bear responsibility for it, but what is the sanction for your breach?
Your Excellencies, the second very important requirement for cessation to arise is that the damages are continuant. And
I'm not speaking about cessation. I'm speaking for any remedy. We should remedy the breach that you acknowledge that you have done.
Your Excellencies, if this court recognizes that we have in fact breached our obligations, we will provide the remedy, for example, reparations to the other party. However, their claim and their their submission is that the appropriate remedy should be cessation, and we maintain that cessation is not the appropriate.
So what would be the appropriate remedy then?
Reparations, for example, Your Excellency.
So you want to pay for damaging
Yes, Your Excellency.
heritage?
Okay, that's nice. We can find that.
Fine.
I have just one
I'm sure the
question
applicants want that.
regarding remedies. What is the normal remedy in international law, agent? Is it reparation?
Usually it's reparations, Your Excellency, or satisfaction when there is a procedural breach of obligations, such as this is the case, and this court has held in the Pope Mills case.
Are you familiar with the restitution integrum?
Yes, Your Excellency. And we maintain that by implementing the program of corrective measures, we are in fact repairing the damages that we have done. And it is the World Heritage Committee's decision that gives us proof that all the damages caused to the World Heritage to the World Heritage are reversible. And if, of course, after the implementation
Time's up. You may finish your sentence.
After the implementation of this program of corrective measures, damages still appear, we would be happy to seize the Savali pipeline operation. But to this day, there is no grounds for cessation. With this, we preclude our first and second submission. My co-agent will now elaborate on the third and fourth points of our submission. Thank you for your time, and if you have no further questions, I shall step off.
Thank you, Councillor. Okay, and indeed we would like to invite the second counsel for the respondent. Yes, ready? Please.
Mr. President, Your Excellencies, my name is Radosław Kostov, and I am honored to appear before the International Court of Justice as an agent of the respondent, the Kingdom of Raja. During the next 22 minutes, we will elaborate on the matters concerning the Ruby SIPA and the compensation regarding the canned migrants. Our third submission regarding the Ruby SIPA will be constructed in 3 main points. First, Rahat has not violated any international obligations concerning the cultural property. Second, Atania has violated its international obligations concerning the protection and preservation of the cultural property. And third, Rahat lawfully possesses the Ruby SIPA. It has been established in the Vienna Convention on the Law of Treaties at Article 24 that a treaty enters into force at the date which is provided in the treaty. And according to the Vienna Convention on the Law of Treaties at Article 26, a state is bound by the norms of the treaty after the treaty has entered into force, and as is stated in clarification number 3, and also in paragraph 21 of the UNESCO Convention from the 1970. This treaty enters into force 3 months after the deposit of the instrument of ratification.
Excuse me, Agent, but I believe that the applicant did not actually plead for the application of this convention. So why are you elaborating on this?
We would like overall to establish that the convention hasn't entered into force, and to appoint the court's attention that it has not entered into force for the respondent. We would like to address...
If we agree, but you brought it upon yourself to begin with, so now I have a question on it. I do recognize that, so perhaps the convention won't apply because exactly of the reasons that you say so. However, there's of course a bit of a problem with that analogy, being that the Vienna Convention on the Law of Treaties, there is a reason why the Vienna Convention has a system where it says that after signing a convention, you cannot define the object and purpose of the treaty. It's a good faith. It's a way to act in good faith in international relations. Now, I completely understand that the UNESCO Convention deviates from that system, but does it mean that there is absolutely no obligation at all under the UNESCO Convention, under any principle of good faith, that would require you to comply with, well, similarly not to define the object and purpose? Could there not be some sort of obligation under good faith?
I understand your concerns, Your Excellency, but it hasn't been established in a state practice what exactly is the object and purpose of the 1970 UNESCO Convention, and therefore it is this court's decision to decide whether the object and purpose have actually been violated. But I would like also to point the court's attention in the case of the United States nationals in Morocco before the International Court of Justice, in which the court ruled that the object and purpose are contained in the preamble of this convention, but only because it is clearly stated that the purpose of this convention, it is stated in the preamble. And in our current case, the purpose or object haven't been stipulated in the preamble of the 1970 UNESCO Convention. And we thus submit that the object and purpose haven't been violated by the respondent.
So do you argue that just because it is not stipulated in the preamble what is the object and purpose, this court is not entitled to interpret the convention and infer its object and purpose?
Indeed, the court is the one that should decide whether the object and purpose have been violated. But I only would like to point that in such cases, courts have ruled in cases where it is explicitly stated that the object and purpose have been stated in the treaty, whether in the preamble or in the heading, or in some articles in the convention, and therefore we still submit that the object and purpose haven't been violated by Rahat.
Okay, Agent, but what the applicant says is that there is international obligation upon your state, whether on basis of the convention or customary international law, but there is international obligation. What is your position on this? Is there any such international obligation? And if there is, what is its source?
In regards to applicant's statement that there is customary international law, it should be clarified that some states parties to the 1970 Convention owe cultural property which have been, for example, excavated on the territory of other states. For example, the Nefertiti bust, which was excavated on the territory of Egypt, but is in Germany at the time, now. But it should be also pointed out that both countries, Germany and Egypt, are also parties to the 1970 Convention, and the Nefertiti bust hasn't been returned back to Egypt, no matter of the fact that it was actually excavated on the territory of Egypt.
Well, of course, you can trade. You may trade if you have consent from the state that has, from which it originates. So if Egypt would have consented to this trade, then I see no problem to it. But if Egypt would not have consented, then maybe that's good state practice.
In recent years, Egypt have stated that they would like to be the Nefertiti bust to be returned, and that is for a very long time, for more than 50 years, they have stated that the Nefertiti bust should be returned back to Egypt. But
and would the fact that it hasn't been returned not show state practice that this rule doesn't exist?
yes, exactly. And I would like to also point the court's attention that Diogenes marbles also haven't been returned back to Greece, which is the state of origin of this cultural property. And therefore, we still submit that the customary rules do not apply in the present compromis.
I think I just made the argument for you. Thank you. Thank you, Councillor. Proceed.
I would like also to point the court's attention that applicant stated the Préavir case in order to the cultural property to be returned. But the applicant neglected the fact that in this case, state agents have taken cultural property from the Préavir, and in our case, Kawadugu took the Ruby Saipar, but she isn't authorized to do it by the country of Rahat, and therefore there is no given authorization. And in this regard, this case is not applicable in our current situation and cannot be applied to our case.
Could you elaborate a little bit more on that? Is it your position then that if the artifacts are held by state agents, then only does your country owe an international obligation to other states? Is that your argument?
Our argument regarding this point is that no authorization was given to Kawadugu to steal the Ruby Sipar from where it was held in storage. And in the case of Préavir, state has given its consent state officials to enter the Préavir and take cultural property from it.
I'm sorry, Agent, but isn't the argument against your state that this cultural artifact is in fact on your territory? Isn't that correct? It's on
Yes,
your territory. Okay. And the applicant comes and says, "Please give back what is mine, because it is my cultural property. It's not yours." And what do you say to this argument? It is clear that your state did not authorize the taking and import of this property, but it is in your, let's say, in your control right now.
To elaborate on this matter, we shall now proceed with our second point of our submission in regards that Athenia has violated its obligations in the protection and lack of display concerning the Ruby Saipar. It has been stated in the compromis at paragraph 50 that a single lady managed to take the Ruby Sipar from where it was held, and therefore there is a lack of adequate preservation, meaning that everyone can enter the vault and take the Ruby Sipar from where it was held and do whatever he wants with this priceless cultural property. And therefore we submit that the applicant hasn't done anything in order to preserve its cultural property adequately.
So, is it then...
What is your legal ground for this alleged violation by Athenia?
States have obligation to safeguard their cultural property. This was established in Article 2 of the 1954 Hague Convention on Protecting Cultural Property in events of armed conflict. But even though there isn't armed conflict in our present case, states still have an obligation to preserve their cultural property.
But what are the parties to this obligation? I mean, the applicant owes this obligation to whom? To your country?
not to our country, but to satisfy the general interest of the universal culture. And because it has been stipulated that we're concerning cultural property, this means that it has some value to states, and therefore states have the duty to safeguard it and present it in order to be observed by future generations.
So you basically say that if the applicant does not take due care for its property, is precluded for lodging a claim for its recovery.
In interest of the safekeeping of the cultural property, we can observe that in the compromis there are turbulent situations in Netanya. Protests outbursted, and also there were some problems with maintaining the public order, and therefore we submit that in our state the cultural property will be preserved better, as it is stated by the cultural minister, Ms. Kassa, in Article 52 of the compromis. It has been stipulated by the European Court of Human Rights in the case of Baylor versus Italy that in order to satisfy the general interest of culture, states have to display its cultural property, and therefore Athenia, by banning the cultural property in paragraph 43 of the compromis, has denied the display of its cultural property. It has been established that the state which provides the better resources and the better preservation of cultural property is the one that should maintain possession. This was also established in the Elgin Marbles case. And
Council, can I ask you a question? Because I think we're going along. The applicants have made the argument that there was a violation on your behalf of your state. Now, I understand that you argue that you did not violate international law. In fact, the applicant state violated international law. So, if my understanding is correctly, then now you're sort of submitting a counterclaim vis-à-vis the applicant.
could you please clarify your question, Your Excellency?
If I understand your argument correctly, then you're saying that the applicant, it is not you, but it is the applicant that violated international law, right? By not displaying the artifacts. So, if that would be the counterclaim then, which is not clearly in the compromis, but if it is a counterclaim, what are the remedies that you seek for that specific claim?
Our remedies in accordance to this is to retain possession of the Rubi-Sipa in order to satisfy the general interest of the universal culture. With our presentation and preservation, we provide better resources for its safekeeping and to be observed by all who wish to see it.
And do you have examples where international courts have found that as a remedy we would allow a state to keep artifacts within a certain country for protection against the actions of another state? Do you have examples for those remedies?
We submit that there aren't any cases, but there is state practice concerning this matter. Having established this, we shall now proceed with our fourth and final submission concerning the kin migrants. It will be constructed in 3 points. First, in cases of international wrongful acts, compensation is sought for the injured state. Second, Athenian conduct in respect to the kin and the sisters of the son directly caused the migrant outflow. And third, such attribution of responsibility to Athenia will limit migrant outflows.
I'm sorry, Agent, but again, I'll ask you a question regarding your standing, because actually, for this claim in particular, the alleged wrongful act occurred on the territory of the applicant and were directed toward their own population. So what is your standing regarding this very particular claim?
There is an international wrongful act which is directed towards the state of Rohat, because states have an obligation not to allow its territory being used in a manner that would harm other states. And being the conduct of human rights violations and the disrespect towards those human rights, there is a migrant outflow towards the country of Rohat.
Yes, Agent, let's admit that there is indeed a wrongful act. Still, what is your standing to bring this claim before the court? In what capacity do you bring this claim?
As the applicant fails to maintain the human rights their population, and we're obliged to accept all of the kin migrants, and with all actions conducted in regards of disrespecting different human rights of the kin clan, and the fact that we are interested in preserving their life as it is stipulated in Article 9 of the International Covenant on Economic and Social Cultural Rights, we're obliged to accept all of the kin migrants. And with the international wrongful conduct on the state of Athenia and the disrespect towards their rights, we are obliged, for example, from the non-refoulement principle, which is according to refugees, to accept all of the refugees and not to return them back to the country of Athenia.
So, what is your position on the legal status of these people? Are they migrants, refugees? What?
Regarding the Sisters of the Sun, they are considered refugees because they have a well-founded fear of being persecuted based on the race, based on, in our case, on a cultural group. In regarding the other kin migrants, we have stated that their cases will be elaborated case by case, because some of them have stated that they flee because of being persecuted, but some of them state that because of fear, because of their starvation they're fleeing, and the non-refoulement principle also spreads to people who are fleeing from famine. This was stipulated by the United Nations High Commissioner on the Refugees when examining the situation between Cambodia and Thailand, in which Thailand stated that it could not longer accommodate the migrants which have outflowed towards the country of Thailand, and must return them back. But the path which is to return them back is covered with mines, and therefore they have violated international law by returning them, and because their life will be endangered, and we have the same obligation if we return the migrants.
Just to clarify your position, because I understand why, I mean, perhaps these people could to a certain extent be qualified as refugees or as any other status under international law. But how is that relevant to your state responsibility claim for damages? What obligation was breached by the applicant that is owed to you? Not to the people for human rights violations, but the obligation that was owed to you.
Not to allow its territory being used in a manner that would harm other states, which was established in the Corfu Channel case before the International Court of Justice. And we, by using its territory to disrespect the kin and the Sisters of the Sun, they had no other alternative.
So if we talk about Corfu Channel then, I mean, that case was the laying of mines, perhaps there was no public emergency, but in this case, there is a clear public emergency. There's drought, these people are fleeing from their lives, so there is a disaster. Now, I recognize that a state has a duty to prevent damages to other states, and perhaps you could apply the Corfu Channel case. My question is, what is the standard of care that is owed by the applicant to the respondent? Because what should they have done?
For example, they should have ensured the right to food directly towards the migrants, which is stated in General Comment number 12 of the Committee on Economic, Social and Cultural Rights, and this right is especially emphasized to people who are minority isolated groups, and in the case of the Salhuyamaksa indigenous community before the Inter-American Court of Human Rights, such emphasis should be put to people who are minorities and are isolated ones. And according to paragraph 11 of the compromis, the kin are exactly such people, and therefore Athenia has violated their obligation to food. And in the same case which I quoted, it has been established that the state should ensure this right directly towards the endangered group. And if we didn't...
Agent, if we assume that some rights of the kin people were breached by Athenia, isn't that they're standing to bring a claim, if this is possible at all, against Athenia, and not you're standing to defend them against some violations that Athenia have probably done to them.
If we hadn't accepted all of the Kingdom migrants, we would breach also international law, also in accordance to Article 9 and the right to life and the non-refoulement principle also, and the right to life is an erga omnes one, which is owed to all people, and if we hadn't ensured the right to food of the Kingdom migrants, we would violate this international obligation.
Yeah, this is clear. Okay, you're protecting these people because they're coming to your territory. But what about your claim against Athenia? What do you want from them, and why?
Your Excellencies, we realize that we claim full compensation for all the hardships we suffered of accommodating the migrants because of the acts of Athenia, and we realize that a finding of the court in our favor would constitute a precedent in the international law of state responsibility for migrant outflows, which concerns our third point. And this is the perfect time for a precedent to be established in order to...
So, Council, what damages do you claim? What precise costs do you claim?
945 million for all costs which are concerning the accommodation of the Ken migrants.
But if I'm not mistaken, those costs do include costs for the maintenance of roads and of security services to maintain a power grid. Is that not a bit of an exaggeration there? And of course you may.
No, indeed, Your Excellency, I understand your concerns, but we wouldn't have suffered those problems if we weren't obliged to accept all of the kin migrants, and therefore, in accordance with the restitutio ad integrum, also in the violation of international law, we submit that the applicant must restore the situation which was prior to the migrant outflow. And with this, we conclude our fourth and final submission, and with the court's permission, I shall step off.
Thank you, Counsel. And then we'll invite the applicant, if you choose to make use of that right, for rebuttal.
In our rebuttal, Atania wishes to provide 2 points. Firstly, the respondent relied on 2 cases in order to disprove the customary rule for restitution of cultural property, namely the Elgin Marbles case and the Nefertiti bust case. However, in those cases, both the states refusing repatriation relied on a claim of legal ownership and claimed that they were not illicitly imported. Therefore, pursuant to paragraph 186 of the Nicaragua case, they relied on an exception contained within the rule and further reaffirmed the existence of this. And secondly, the respondent failed to establish legal interest with regards to the fourth claim and accordingly standing to invoke the responsibility of Atania for any human rights violations allegedly committed by the applicants. It is not sufficient to prove that there was injury to the state, but they are required to prove that the obligation was owed to them, and they have failed to do so, and pursuant to Article 42 of the Articles on State Responsibility and to the Southwest Africa case, they have failed to establish their standing. Thank you for your kind attention.
We will invite the respondents to present their rebuttal, if you like.
In exercising our right to serve rebuttal, we would like to point the court's attention towards the first point stated by the applicant. The applicant stated that the ownership is within Germany, but according to the 1970 Convention on the illicit import and export of cultural property, which both Germany and Egypt are parties of, the property is belonging to the state on which territory the property was excavated, and this is more specifically Article 1, subparagraph B. And as it can be seen in recent years, Egypt have stated that they have claimed ownership also, and their rightful rights towards the Nefertiti bust. And with this, we established that the applicant hasn't maintained the fact that ownership should be concerned in regard to the 1917 Convention, in which both Germany and Egypt are parties of.
Thank you, Councillor.
With this, we conclude, and with the proposed commission.
Thank you. And with that, this concludes this session. We thank both the applicants and respondent for presenting their arguments. Thank you very much. This has been a very interesting national round. I look to the administrator if they want us to leave, which I assume would be a nice thing to do. So thank you very much. We will deliberate and we will come back once we know. Thank you. Be seated, be seated. We're not a real court. Thank you very much. We promised to be nice now, so the rounds are over. Thank you very much for a very good final round. We were very impressed. I will tell you that we think that it's an exceptional high level. I've judged many jessup teams. I've judged many national rounds. I loved this round. So thank you very much for this. It was close, so it took us a while to deliberate to find out who the winner is, and we will announce that shortly. But before we do, we have some general remarks. We will give you feedback, and it's only to assist you in your further careers and your advocacy skills, which is a difficult word. So let me start off by thanking you, your coaches, all the other teams, all the other coaches, and the judges for participating in jessup. I myself have now participated in jessup for 10 years as a judge. I participated before, and I can tell you jessup is really nice, and it is important for your careers. So I would really urge you stay with jessup, participate again, coach, judge, whatever you like to do, but it is a very nice family to stay with, both in this country and if ever you have the opportunity to go to Washington, D.C. or any other national round, it is really nice to go there. We have a big family of friends, we help each other out. It is a very big international community. If you just have the example, of course, we're all aware of President Trump's order not to have the immigration into the United States. This affects the competition, but we have very good immigration lawyers on the international round, and they're actually making a case now to get all the Iraqis and the Afghani national teams in the US. These are the people that are part of our friends. These are the people that we know, so I hope that you stay with jessup, be one of those people, and do what's good for the international relations, do what's good for international law. On that note, I will give the word to you.
Okay. I will be quick, as I know that now you just want to have the result of this round. First of all, let me introduce myself. So my name is Anne-Gilles. I studied and had a PhD at the Sorbonne Law School, and now I teach international economic law. So I like international law, and I've been involved in the jessup for something like 10 or 12 years, first as a competitor, second as a coach, and now as a judge. So just as Bart said, it was really a tremendous round, in my opinion, because it was all the time very close, and you made really an effort to respond and to each other, which is really, I think, the point of a pleading. So it was really good from this perspective. Now, I will give you just short feedbacks as teams, and I hope that it will help you well, if you go to DC, and as Bart said, even if you're in your career and so on. So, regarding the applicant, I think that maybe one point that you can enhance is to try to look around the specific questions of the case, because you don't know what kind of questions can be asked. So maybe to try to see questions that are not directly part of the case, but can be used to understand a point. So maybe to try to see a bit around. Now, regarding the respondent, I think that being the respondent is maybe the most interesting position, but also the most difficult, because you have to answer the applicant's arguments, what you did most of the time. But sometimes don't lose the applicant's argument. Don't try just to make your point and to keep your pleading as pretty and beautiful as they were at the beginning. Try to really answer what they decided to treat. So this is very general comments, and I hope that they will be useful for you as people and as a team. So thank you.
Hello from my side. As you can see, my name is Dejan Dragiev. I, strangely enough, have not been part of jessup competitors, but even more stranger, I have been part of jessup judges for, it's about 4 or 5 years. I was on the final bench last year when we saw, again, a very disputed and very close battle, which we saw today as well. And I'm very honored and privileged to be judging this high level of teams, and it seems that each year the level of teams is going higher and higher, which proves that jessup has spawned a community of developing lawyers which will have even better advocacy skills when they enter in their practice. I won't play with your nerves, because all you want to know is who is winning. And I'll just give some very general comments. Briefly, the first one is that both teams showed very high level knowledge of the law and the facts of the case. But what I recommend is that you have also to look into the deeper principles of international law, because when you're being asked a question, on many instances, you had to make a distinction between the source of law and the basis of obligations, and so on. And it seems that you have to go back to all these things and look them again before going to the final rounds. As to the applicant team, you had a very good presentation and very good knowledge of the facts and the law and lots of different precedents. But I also recommend, besides enhancing what you already have, I also recommend that you go into this distinction between the different sources of obligations and so on, because it would do you good for the next stages. As for the respondent team, again, they have very interesting and original twists in their arguments, which I really liked. And I think this is good, because these types of competitions should enhance the originality of the competitors. What I would recommend is that you have to put your legal arguments very clearly in the beginning of your speeches, because what we saw is that you have very fine arguments, but they come up after being asked questions. So what you have to develop for the next stages is like putting your short, emphasized arguments on the beginning of your speeches. Otherwise, you are very, very good in your presentation and very persuasive, and it is an honor for me to be listening and judging your presentation today. Thank you.
Well, and then I'll just introduce myself, give some brief comments, and then we will announce the winner. My name is Bart Vis. I come from the Netherlands. I am Dutch. I participated in 2005 in the jessup, and I judged the international rounds in 2007, 8, 9, 10, until, well, forever. So this year will be my 10th year judging the jessup. That's really nice. It's a decade. That's how much I love jessup. I've judged many national rounds as well. And this level, as I said, is very high, so congratulations. I'm going to give some general comments to get a little bit more feeling as to how these proceedings go. You've done really well, but the question, of course, is always how to make it better, how to make it sexy. Now, Argumentation is, of course, a skill in itself. You won't know, you have to learn this, and you've started learning this. And in that respect, you're way ahead of your peers. So if ever you go to work for law firms or courts or whatever, you will notice, as I noticed when I started practicing law, that you're far beyond the skills of all your competitors, simply because it will never be worse or more scarier than it is in these halls. So congratulate now. It will only be easier from this point on. As for the skills, I always think what I like, but it is of course a personal perspective for me, but for the applicant controls the proceedings, okay? You have the floor for the first time. You determine which arguments you're going to argue. So your line of argument is the argument that the respondent will have to follow. That gives you a great benefit, because it allows you to bring your stronger arguments, but it also is a negative thing, because the respondent is allowed to respond to your questions. Now that is difficult, because it means you cannot really prepare your briefs, but it allows you to really respond to the arguments made by the applicant. So, when you argue, the respondent should always argue, well, Your Excellencies, the applicants have argued, blah, blah, blah. Contrary to the position of the applicants, we submit, blah, blah, blah. And then you put together the submissions of the applicant and you show them already why those submissions are wrong. So you have a surrebuttal for 45 minutes. If you do it that way, that's very powerful. And in certain instances, I saw that you did refer to the positions taken by the applicant. And I think that's very well done. What can you do as an applicant to make it sexy? Why not go for the memorials? Take the memorials of the respondent and say, well, Your Excellencies, during your pleadings, you can do exactly the same thing. You take your best points, you are the one who decide as applicant what the roadmap will be, but you can infer from the memos of the respondent. And we've read them, so we know what's in there. So you can use that to make it sexy in the same way as the respondent can go. Those are my general comments. I would like to congratulate you all for participating. And on that happy note, I think we shall announce the winner, if that's okay. So the winner of the national championship round and the one who will participate in the competition in Washington, D.C. is the applicant. Congratulations.
I congratulate the team of Sofia University St. Clement Ochridsky with the win, with the championship cup, and I invite you to receive your trophy. Please come to the floor. Okay, I also would like to congratulate the runner-up from the team of Plovdiv University, Pejsek Filandarski, with a very good performance. Okay, big thanks to the teams. Great gratitude for our judges, and of course thanks for you for giving part of your Sunday to be here and to see the Bulgarian national champion, who will be in the United States in April and will represent Bulgaria among 150 other teams. Thank you very much, we wish them luck, and with this I officially announce the 7th Bulgarian national rounds of jessup for closed. Thank you.